Good morning, good afternoon. Welcome everybody to IDS Talks podcast. I'm delighted to be joined not only by Dan Rupprecht, a frequent guest, but Miss Eleonor Duhs of Bates Wells here in London. You'll learn a bit more about her in a moment, but she's saying hello from her offices here in London. Say hello, Eleonor.
Hi. Great to be here. Thank you so much for inviting me, Tim and Dan.
You're very welcome. We really look forward to the chat. A lot of people might be familiar with Dan and myself, but we'll do a really quick background about who we are and who the firm are prior to handing it over to you, where you shouldn't be modest in telling us about your expertise and background. Again, I'm Tim LaTulippe. I'm one of the directors here in the business here in London. IDS are a almost 15-year-old data services and electronic discovery firm founded in the United States. We're Chambers ranked. We're all over America, and we support European clients from here in London. My background is data forensic examiner, expert witness, very technical. Dan Rupprecht's background is a little bit different, but I will let him explain that.
Yeah, thanks, Tim. As Tim mentioned, I have a little bit of a different background than he does, and rather than focusing primarily on the technical side of the aspects in our day-to-day work, I take a more lawyerly perspective. My background is that of an attorney, and I often sit as sort of a translator between the technology specialists and the lawyers that we work alongside. Really sort of creating workflows and developing solutions that best meet the goals of the matters at hand. So I often say where Tim builds the universe of data to consider, it's my job to figure out ways to take that apart and get to the evidence that we're after. So together we formulate a very sort of unique tandem that covers the entirety of the EDRM. And yes, we're joined today by Eleonor, who's become quite a good friend of ours and definitely a sounding board in all things data protection. But there's no one better to explain your background than you, Eleonor. So over to you.
Thank you so much, Dan. So I'm Eleonor Duhs. I'm a partner and head of data privacy at Bates Wells, which is a law firm based in the City of London. Prior to working at Bates Wells, I was a UK government lawyer, and I was fortunate enough to be part of the GDPR negotiations in Brussels. So I was the government's lead lawyer. So spent a number of years travelling from London to Brussels and back, discussing this piece of legislation, which of course applies in the EU. And extraterritorially. So it was a really fascinating experience to be part of that negotiation. After that, I worked on a number of other EU law matters in government in the Foreign Office, and my final posting was in the Department for Exiting the EU. So I led on the core provisions of the domestic legislation, which gave effect to Brexit, as well as working on the withdrawal agreement between the UK and the EU and the framework for the future UK-EU relationship. And so I advise on Brexit, but also very much, of course, on all aspects of data protection, including international matters, international transfers, and that sort of thing.
Thank you, Eleonor. So you are the right person to join this talk, after all. This is going to be very useful. Thank you very much. We were recently, as Dan mentioned, we've become friends quite recently. We were joined together at an event in Vienna in the middle of October. The International Association of Defense Counsel, the IADC, they're over a century old now. Their corporate counsel college meeting in Europe annually, COVID notwithstanding, is usually in places like Brussels, Paris, you name it, Berlin. They move around. And I've been going for many years, and it was a delight to be back in person and moderating a panel once again, which you joined, Eleonor. The theme of the whole event in Vienna was actually setting the course in unsteady times. Someone's going to fact check this later, I hope, but that was the sort of core theme of the meetings at large. And there's quite a lot going on when you unpack that term. There's a lot going on in the world. You mentioned the dreaded B word a moment ago. We had a pandemic. We have a war on European soil. We've got austerity that'll surely follow, economic recession and financial pains. So we've kind of been living through almost 3 once in a generation kind of events in a quite compact period of time. I know it's sort of a loaded question, but I guess first question, just to get the ball rolling, Dan, how does this affect the IDS firm and the practice that you're sitting in? I mean, there's a lot going on in the world right now.
I mean, we deal with data and on the matters that we work on, and the clients that we deal with, we're often dealing with global matters. We're dealing with many jurisdictions all over the world, and problems don't really have borders. And in that sense, we've always been prepared for the world that we're now currently faced with. During the pandemic, we were told to work from home. We now live in a hybrid type environment where people are still a little bit reticent about going back into the office. Where some industries may have to really sort of reformulate how they purpose their own organizations. We've actually always been living in this sort of hybrid environment and have already been prepared for a work at home type mentality. So in terms of, how have things changed for IDS in particular, I think it's not so much what we've needed to do to sort of prepare for this new world order that we're dealing with. It's more about how are we now expressing these differences to the organizations that are now trying to reorganize to work in these types of environments. So I think for us, it's shown that there is great opportunity to use technology within organizations across all communicative chains, and we're seeing a lot of efficiencies come out of that. So again, it's not all dire, and I do think that there are great avenues of ingenuity that we've seen come out of these once in a generation events that we're now dealing with.
Eleanor, anything come to mind from your perspective?
Well, in the UK, we've had an awful lot of uncertainty for the last few years, really. With Brexit, firms are wondering what's going to happen, what kind of data protection frameworks in particular are we going to have. We saved all of the EU rights and obligations, including GDPR, that applied in our law the moment that we stopped being subject to the EU treaties. So on Brexit, everything was saved. But now the government is thinking, actually, we want to rip all this up. And so the thing that everyone is asking is what's going to happen? Are we going to have that continuity? Are we going to have interoperability with the EU regime? Or are we going to be doing something completely different? And nobody knows the answer to that. And I don't think ministers do either. So it's a huge amount of uncertainty for everyone to think about and work through and plan for. And we don't know what that is yet.
Yeah, and if you were to timestamp this video, the 21st of October, 2022, our government is increasingly unstable if you rewind 24 hours from today. So yeah, there's plenty to unpack there. So one of the things we talked about in Vienna, which is quite timely, Cecilia Alvarez, our friend at Meta, brought this up, at least teed off the conversation. But we can move into some takeaways from Vienna actually in a little bit, but there's this sort of looming concern that some of us have in Great Britain and the UK largely about adequacy in terms of data being a sort of adequate data transfer zone, let's say, to recap it for our listeners. The UK has largely enjoyed kind of parallel adequacy status with the rest of the EEA or EU at large. Therefore, data coming from the Netherlands is treated the same way in the UK as it would be in the Netherlands, for instance. The issue with the United States, albeit a great partner for the United Kingdom in a lot of respects, and of course my alma mater and home country, is that they've for the most part been an inadequate place for data to flow from Europe. And I think this is largely on national security grounds and not for any commercial reasons. But what do you make of the executive order that happened on, I think, the 7th of October? Fact check me, Eleanor, but what do you make of that?
Yeah. Friday, the 7th of October was a big day. And I think a really positive one. So since the Schrems 2 case 2 years ago, which invalidated Privacy Shield, which allowed the free flow of data from the EU to US companies that subscribe to Privacy Shield, that was invalidated by the Court of Justice. And we have been waiting for a solution to that. And this looks positive, I have to say. I think there's been a huge amount done. There's been a real reflection, I think, of how you need to bring the standard of protection up for that national security data that flows from the EU to the US. And I think everyone is breathing a sigh of relief. This has been a long time coming. People have had to do an awful lot of analysis before they've been able to send the data. So this should help, even if you're not a subscriber to Privacy Shield 2, whatever they're going to call it, even if you're sending on the basis of standard contractual clauses. The executive order and the DOJ regulations should help a lot. But of course, we know that there are privacy activists waiting in the wings. Max Schrems, whose name, of course, is associated with that CJU case of 2 years ago, is poised to bring another action. So I think we've got some stability for a while, and we'll see what happens. But it is a really positive development.
Yeah, thank you. And Dan, you're, as a practitioner in sort of electronic data consulting, and also as a commercial director of a business. I mean, how does this make you feel? I mean, this has been quite a looming issue for a wee while.
Yeah, I mean, all I can say is, phew. It is something that we think about on a daily basis here. We operate out of the United Kingdom, but we're across the continent and around the world. And for us and the matters that we work on, as I mentioned before, we're global in nature, and the free flow of data is very important to our industry. It's something we keep a close eye on, and Eleanor and I were talking about this at length yesterday. With the GDPR and the way that it's written, it has a very sort of broad stroke in terms of what it allows and what it doesn't allow, and it's open to quite a bit of interpretation. But what we're starting to see is identification of some guardrails and some indicators on what's right and what's wrong when we're dealing with data protection and data transfer. So I think this is just one step closer to getting some clarity on what we need to do, and that, as a practitioner and as someone who advises on these types of matters, these types of clarification points is really what we're finding helpful as we move forward in interpreting the GDPR.
Yeah, thanks, Dan. And I think you may well have covered this, Eleanor, regarding Schrems, but executive orders are sort of punchy and bold and make headlines. But do you, and apologies if you don't want to weigh in on US jurisprudence, maybe Dan does, but do you foresee any sort of challenge to this executive order, as is often the case with such bold executive orders, regardless of the administration?
Well, I don't know from a US perspective. I'll leave Dan to talk about that. But certainly from an EU and UK perspective, I think activists will be saying, this isn't enough, this isn't good enough. So, I mean, this litigation will take time. So I think for a while we can breathe a sigh of relief. But I think do need to keep an eye on all of this, because, twice now the Court of Justice has taken the view that what was done by the European Commission and what was done in the US just wasn't good enough. So that could happen again. I hope it doesn't, but I think we need to be aware of that possibility.
Yeah, good point. I want to jump back to our IEDC panel and meetings in Vienna quickly, because I thought our colleagues shared some pretty interesting insights during our panel. It was quite early in the morning, and I think we'd sort of tied one on the night before at a nice dinner. So maybe people weren't incredibly active at that time of the morning, but people were still engaged, and there were a couple of insights, and one of which I wanted to share, Eleanor, and maybe you have one that you want to take away from Vienna as well. But an old friend and contact during the meeting stood up, an American lawyer, actually, and practitioner. And he had mentioned a case that involved a French entity that was facing a dispute of some kind, litigation of some description. And I think it was the US state of Arizona, somewhere in the Southwest. And they had sort of come to some kind of compromise through a protective order or something similar, where they basically stated in their application to the judge that they would look after the data and protect its security and the sort of privacy of those in the data inherited to third parties as well. And it was an interesting sort of approach. It was almost an offensive move, if you're using sports terms, to say, look, I know you're going to discuss blocking statutes and legitimate laws that you have on the books in France, but here's what we're prepared to do, because as an American federal jurisdiction, we are entitled to these data and this discovery order, but we are willing to meet you in the middle. I thought that was interesting, and it was a fairly recent case. So I like to hear these anecdotes from litigators in America whenever we can. Did you have any particular takeaways from the audience?
Yeah, no, definitely. I think what one of my panelists said was, I think fellow panelists said was quite shocking to all of us, which was that some of this data which has been sent over to the US has been used for completely different purposes. So, for example, you're sent to insurers and sold and that sort of thing, which is totally contrary to what should happen under European data protection law. You've got to be very clear about your purposes, and you should not be sending the data on in an insecure fashion or to others who don't have access to it. So I think that was a bit of a surprise that is happening, and certainly something that would breach European data protection law. But I think the other thing was that often, you'll get a court order in the US and you'll be expected to react really, really quickly, and people want the data there and then. And actually, that's not how the EU regime works. And it's really important, if you can plan ahead, you should do so. But you should also emphasize that this regime can be complied with, but it takes time. You need to be clear what data falls within the scope of the order to disclose. You shouldn't be sending more than you need to. You need to ensure that there's a proper legal basis, a proper justification, that it's proportionate. This is all documented. So yes, there are helpful precedents out there for these regimes talking to each other and being able to interact, as it were, like the French example that you mentioned, Tim. But this is a regime, this European regime, which is quite burdensome, and you can't just send the data over. You need proper thought and a strategy around how you do that safely and in compliance with the law.
Yeah, consideration is key, which is something we consider, to reuse the term, with our clients broadly all of the time when they're faced with responding to regulatory requests or discovery orders in the context of a dispute in America. But that's a great point for you, Dan. I mean, how do you logistically and sort of operationally deal with this at IDS when this comes up? There's a lot of moving parts here, and we'll shift to Eleanor for the more legal focus and how she advises clients. But how do you deal with it as a consultant and practitioner in data investigations?
Well, I think what has really happened, and one of the silver linings, if you can call it that, of the GDPR and the advent of 2018 and its enforcement or inaction into law and regulation, is that it really lit the fire under organizations to understand how data flows through their organizations, and more importantly, it provided budgets to help guide that process. So most organizations of a particular size now have DPOs internally that really are tasked with understanding how their digital environment is not only operating within their corporate environments, but how individuals are interacting with those same networks. So from an investigative standpoint and from an advisory perspective, as a consultant dealing with digital environments and evidence, really it all boils down to how well do you know your network? How well do you know the data that you deal with on a daily basis? And I always say that as we start collaborating and working with our clients, we want to avoid as many of the I don't know answers to the questions I may have as they come up. And I think that the GDPR has inadvertently helped in that regard. You know, there's less I don't know around these days, because you have to know what you're holding. You need to know where certain evidence or certain data lies, and how to extract that or get to that information. So from a logistical perspective, I think a lot of the benefit that's come from this is a better understanding of information governance, and a better understanding of what liability might lie therein. So again, we're getting better answers to the questions that we ask.
Mm. And what about you, Eleanor, from a sort of legal perspective? How are you advising clients in this respect? I know that's a very broad question.
It's a difficult regime to comply with. It's complex from the point of view that you have to be able to justify what you're doing. You have to make sure that your arguments are watertight for holding data, sharing data, but it's absolutely crucial. I mean, this regime is now one that people are familiar with. So you do get data subjects saying, what are you doing with my data? And that goes back to the point that Dan made. You need to know what's happening within your organization. And as our regulator, the ICO, says in the UK, you've got to embed a culture of respect for privacy, for the respect for the protection of personal data within your organization. And it's those organizations that haven't done that which are in difficulty, because mostly if you've done what you need to and something goes wrong, you've got something to show the regulator, and they will be certainly in the UK, satisfied with the fact that you've tried. Because it's so complex, sometimes there will be different answers to how you balance organizations' rights against the privacy rights of the individual, but you really do need to have embedded that compliance program and to be able to show that you were taking people's rights seriously.
Mm. And you mentioned the word culture there. That always just is kind of an ear buzzer for me. And do you think regionally, national level or regional sort of level culture has an impact on this and in the way that businesses and individuals treat data and data privacy generally? I mean, I know my answer to that question, but I wondered what you thought about that, Eleanor.
Absolutely. I think certain information is really sensitive in particular cultures. So in the UK, we never talk about how much we earn, whereas in Sweden, for example, which was a fellow EU country a few months ago, everyone knows exactly what everybody earns, and that's not sensitive at all. So there are cultural differences, but the GDPR is very clear about there's a list of sensitive information, and that has to be treated with extra protections. So there are differences, cultural differences, but there's also an attempt really to harmonize and to provide those protections for specific named types of data, like health data, for example.
Yes. Yeah. Thank you for that. We talked a little bit about an event we recently attended. There's one that you're attending in the coming weeks or month or so, Eleanor. It's actually, I'll actually let Dan introduce it, because this is his old stomping grounds and his old backyard.
Yeah, I used to operate just outside of Georgetown. So Georgetown is putting on an advanced eDiscovery Institute. It's a yearly conference that really brings together thought leaders around the world to talk about technology, eDiscovery, cross-border issues, data protection, sort of all things that encompass the sort of digital investigatory and sort of evidentiary understanding with the cases that we're working on. So it's a great opportunity to learn what people are doing from around the world, learn about new technologies and techniques that are being applied in creative ways, and really to get into a room with individuals who are driving these conversations and really pushing our profession to the next level. It's a conference that iDiscovery Solutions has sponsored for years. We've spoken at it, have been very involved in the planning stages of the conference through our CEO and visionary Dan Regard. Even this year, our COO, Hunter McMahon, will be speaking at the event on the Great Resignation and how to collect and preserve and really evaluate data that employees hold or take with them potentially as they leave. But again, there are some incredible topics that will be discussed over the course of the 2 days, which happens on November 17th and 18th. Also, former bosses of mine are joining there. Natasha Gerlach is a very close friend and former colleague. And I think Eleanor, you're speaking on a panel with her. So
I
over to
am.
you.
Yeah, no, indeed, it's a
Yeah.
great pleasure always to discuss these issues with Natasha. So we're talking about Show Me the Way, proposed reforms in the UK, the new data transfer agreement and the old Schrems, how to move data from A to B in the future. So that panel is on the 18th of November from 10 to 11 a.m. US time, and it's going to be fascinating because these topics are, evolving week by week almost. So by then, will we know what the direction of travel is for the UK? I don't know, but we'll be able to speculate and give you our best assessment, and also talk about the executive order, data transfers to the US, and the EU position as well. So it'll be a fascinating panel, and I hope you'll be able to join us.
Indeed, indeed. I still think "See You on the Other Side" (EU) was a better title. But I just want
It was
to
very
get on the
good.
record.
You get a gold star for that, Tim. Don't worry.
Yeah. Well, I really want to thank you both for taking the time. I speak obviously personally when I say it's always a pleasure to speak to you both, and I always walk away more educated and energized than when I started. And I hope our listeners and viewers feel the same. So thank you very much, and virtually join me in thanking these two for spending the time. Thank you very much.
Thank you
Thanks,
so
everyone.
much. Thank you. Bye.